And kindly have a look at your lordships. All these recognitions prior to your lordships coming into force of the Right to Education Act. All these registrations. One is 88, another is 91. This, your lordships, act came into force in, if I'm not wrong, your lordships, and just your page 35, I give your lordships the date. In 2026 August 2009, your lordships will get that from page 35 of the spiral binding. Atti Act, ultimately effect was given, my lord, in 2010, 16th February. At the bottom, your lordships will get it. By notification dated such and such. At the bottom, number 1, your lordships will get it. So all these registration, not even recognition, under the different acts, your lordships, prior to this act, they cannot, there was no such recognition process like that. After this act, no person is entitled to run a private school without the recognition. The logic is that government must have a control on the system of education. What you are teaching to the school, what is your standard? Because you are collecting money from the parents. You are not paying from out of your pocket. So government must have a control to every recognized school. That's why recognition clause. In respect of unaided even. Aided must be. So, my lord, what I'm trying to impress upon your lordships, I will show other things also. That how this was done, the appointment.
Yes.
Now, this is an appointment letter. Your lordships kindly have a look at the date, page 1036, 26.
Sir, come back in. Let Mr. Sir.
I'm একটু সময় নেব তুই যা 26 December 2014, page 103. I give an example because all of them like this. Now your lordships kindly have a look at the contents of this. I am pleased to inform you that you have been appointed for the role of assistant teacher in our institution. This is an official letter confirming your employment with Shonirbhar Shiksha Niketan starting on 3rd January 2015. Well, kindly mark date. 15. The appointment, then another appointment, I don't know. The appointment of Kisholoy Noskar is on temporary basis. And then you're subject to the terms, all that. Now, my lord, I take your losses to date, appointment letter date, and my lord, starting from date. I will take your losses to the Supreme Court judgment when the Supreme Court has narrated the history of this 18 months old way. My lord, this started from this date. What I'm on, that these sort of appointments have all been made after this process started, so that they can, on the basis of in-service teacher, get the 18 months DLED. Because otherwise competition is there. You have to go to the market to compete with thousands of students and then get you selected. But if you can show I am in service, you will permit it to 18 months. So this is a fraud on that.
Okay.
Then now all are unrecognized. Now your lordships kindly will look at this page 104. Shankarshar Barman, that at appointment letter Shankarshar Barman. Just your lordships kindly let me read it. 28th August 2005, this certificate is issued. This is to certify that such and such has been working, my lord. Present continuous tense, my lord. In the form eto to eto. But how could it be? Therefore, after 19th, he didn't work. He is sincere and continually satisfied with his service. Kindly see only from 15 to 19. If I take your losses Supreme Court judgment, everything happened during this period. So this appointment letter was issued to show that he is an in-service candidate and so that he can pursue 18 years. So, they have to satisfy. Now, I am satisfying your lordships. They kindly see their conduct. Now, how they did this decree. Now, your lordships, page 107. Kindly see, this is Lal Bahadur Shastri Samarak Bengali Hindi High School. Malad, where is the registration? Malad, I'm putting a question to myself. Recognition. Every school, if this is said, this is recognized REGD number such and such. But kindly request them to produce that recognition letter of these schools. Then your losses kindly see, he is a contractual teacher of 2011 of classes 5 to 8 Hindi medium and political science. We are concerned with primary teacher 1 to 5. Political science is not at all a subject, my lord. Someone goes on this basis and they, 18 months, which is one time for those who are really in service. Then your losses will get it. 108, the appointment letter. I am not taking your losses to that. 111. Only one appointment letter, my lord, I have got the salary. None of the appointment letters, your lordships will find salary. No salary sheet annexed. No requisition slip annexed that they used to get salary. It's it's like a certificate issued character because they are not paid. Let them produce their bank account showing that they have received the salary for the entire period. Only this appointment letter, I am showing this because I got it only in one appointment letter, at least mentioned the salary 4,000, but unrecognized. Again.
Yes.
Now, just take your lordships the pagination page number 112, 119, 123, 124, like this, 127, 128. These are all like these appointment letters. I have gone through, I am not taking your losses, wasting your losses time also. But two more I will show to your losses again. 115 and 116. I don't know, whether their certificate should be called back or not. This is 115 higher secondary school. 12th class. By the direction of the managing committee, inform you that you have been appointed as computer teacher of the school. In the primary section, there is no computer business.
Yes.
Does it? I don't know whether their submission will be to this extent. Wherever I work as a teacher, I can get it. DLED. DLED only for your losses, those qualified teachers. They have all appointed, if I'm not wrong, after 2010, Right to Education Act, 2010 NCT notification. Even the private school cannot appointment without securing 50% marks of the candidates. Where are those appointments? Clear to your lordships? There is no distinction in respect of qualification of the teachers. If you want to get your job in the aided school, you have to compete. But if you want to get a private school, you are merely go and do that. But you have to satisfy those conditions. These were not before the Supreme Court. Because Supreme Court was on the point of law. Whether 18 months course, who did it as an in-service teacher, whether they can be considered in the subsequent process or not. Supreme Court says, initially said no, it's not equivalent, I will take your lordships, subsequently modified. So my submissions, your lordships, on these sort of appointment letters, they secured the completion of that course, which they otherwise not entitled. Now kindly see 116. This is of 2005 certificate. That Niranjan Rai, 115, his appointment letter and experience certificate, kindly see. This is to certify Niranjan Rai, such and such of Alipurduar, has been working in the post of normal section as a contractual computer teacher of such and such high school. Till date, he is performing the task seriously, sincerely, and satisfactorily. There is no averment in the petition, nor does it appear from any of the documents whether they are higher secondary pass or not. Well, even a non-matric can do very well do computer functioning. What sort of qualification? Did you get the 50% marks in higher secondary examination? No qualification mentioned. So it's if someone gets a computer trained person without any qualification and they get 1,000, 2,000 rupees or 3,000, obviously private bodies to the private institution lucrative because they are getting the job. But that's not the standard of education, Mala. And entire thing your losses will find, and there is no contractual teacher. And then Malad 119. Siliguri Public Co-ed School, no recognition. None of the school, your lordships, their letterhead says they are recognized. Kindly see the appointment date 26 June 2017. Your losses, the 2 years gap, your losses, kindly remember from August 2017 to July 2019, if I'm not wrong. When the appointment secured? Yes. From an unrecognized school, completed as in-service teacher. Now I take your lordships to this notification. আমার কাছে নেই এটা তো আমাদের গাইডলাইনও আছে এখানে kindly have a look at this Ministry of Human Resources guidelines. I have certain submissions. This is of 8 November 2010. Guidelines under section 35 of the Right to Free Education Compulsory Act for implementation of the provisions of section 23G. Well, this has been issued by MHIT, the nodal department of the central government. National Council for Teacher Education has, in exercise of the powers conferred by section 23(1), laid down the minimum qualifications for a person to be eligible for appointment as a teacher in schools, vide notification dated 23rd August 2010. This notification has already been circulated to the state government and other authorities. The notification can also be downloaded from the website. Accordingly, all appointments of teachers, kindly consider your losses, in classes 1 to 8, in respect of all schools referred to in clause N of section 2, I have taken your losses to that because of this, have to be made in accordance with this notification. That's why I'm harping before your lordships. Even in the private school, if you are a recognized school, you are coming under the 2N. First of all, you are not coming under 2N because these are unrecognized. If they can show, that's another issue. I do not find from the pleading or from any document. Secondly, even if you are recognized, you have to comply 23rd August 2010. That means higher secondary, your lordships, 50% marks and 2-year diploma. That was relaxed, your lordships. But what not relaxed, I will take your lordships to that. Lord, your lordships will find in 23rd August 2010 notification, I need not place it, your lordships. TET is a must. Now, your lordships, of this notification, I handed up clause 4. The condition of passing TET will not be relaxed by the central government. So one cannot be appointed even in unaided private recognized school without TET. You cannot. That's why, your lordships, TET, the certificate is valid for indefinite period, for whole life. Why? If you cannot secure an appointment in aided school government job, you can do it with this qualification in private schools. So this was not relaxed. But what is their case before your lordships? In 2017, as in-service teacher, I'm sorry. Yes. In 2017, as in-service teacher, they admitted themselves in the course, and 2019. But when they got the TET pass, that, your lordships, all are TET pass in 2022. Page 122, your lordships, kindly. One of the certificate.
Others have not passed.
Well, all pass 2022. One I am showing to your lordship, they have annexed. Probably they have annexed others also. Not all. 2022, I am on what? On clause 4. So when you are appointed without passing TET, how could you be appointed? It's an illegal appointment. Even the school is recognized. Because you did not qualify, fulfill the conditions of NCT of 2010. So without TET, you are in service teacher, which you could not be. Now, law is as of today after 2010 August, even in recognized private school, authority cannot appoint a teacher without compliance of 23rd August 2010 in primary schools. We are not, we are duped. We are duped by the authorities because we do not know. Most of our children are in the private sector. We do not know how many of them have TET pass. This is an illegality. But court cannot be a mute spectator to this. You cannot get the reap of the benefit on the basis of your illegalities.
As per the averments in the writ petition, they are all past it 2022 or
Exactly, 2022.
22.
So they could not sit for private school. The authorities did not verify all this. This was not the case either before the Honorable Supreme Court. Supreme Court issue was only whether those who passed DLED in 18 months as in service, whether they can be allowed to participate in the next recruitment process. Ultimately, issue was that whether this is at all a qualification for the recruitment purpose. Initially said, my lord, in Jaibi Singh, no. I will take your lordships. So for the factual background is, these are the factual.
As per you, before the Honorable Supreme Court, the other conditions were satisfied by the petitioners before the Honorable Supreme Court.
I am not sure in that.
না না না
I'm not,
সেটা নয়, তার কারণ হচ্ছে আমাদের ওইখানে যে অর্ডারটা ছিল আমরা 30/5 এই যে এইটা দিয়েছিলাম না 30
no, that's your lordships. I will clarify that. That was not there. And that was, my lord, not before the Supreme Court also. We have clarified that. And today I have come to know that in 2022 selection process, we wanted to verify all these and issued a notification. They questioned it before the Supreme Court, relying upon Kaushik Chand judgment. So probably they have withdrawn it today. I have got the judgment, seen the judgment today. I will show to that. So our requirements, my lord, as today, my lord, that's valid what we are asked. But we are, that's a 2020 selection process. That was during the pendency. But this is, my lord, just to have started. They have to satisfy your lordships. Or the petition will show. Why should I allow a candidate, my lord, who doesn't fulfill the conditions? Prima facie. His document shows that he is not entitled to the benefit of 18 months courses.
Yes.
Now your lordships, I take your lordships to the JBC judgment ana okay.
কোনটা
ওই যেটা আজকে দেখলাম একটা কোথায় হয়েছে
এইটা
না উইথড্র করে নিয়েছে কবে দেখলাম আজকে ও আচ্ছা সেটা আমি দেখাবো Now your lordships have been shown the main judgment of JB Singh of dated 28th November 2023. I just take your lordships to that judgment. না এটা তো জয়বীর সিং এর মেইন জাজমেন্টটা কই
এইটাই তো মেইন জাজমেন্ট
23 আগস্ট কি
হ্যাঁ
না দেখছি
এটা রিপোর্টেড কপি দেখি তোদের কি কপি আছে রিপোর্টেড কপি এটা
না এখানে তো হোল্ড করলো যে
Paragraph 41.
মানে the paragraph where because online মানে and another এটা কি জসিম প্যারাগ্রাফ
দর্শককে দেব
দেখি না জসিমকে দিয়েছে ওরা
The paragraph where Ram Saran Maura has been quoted, just
paragraph
before, where Ram Saran Maura has been
আচ্ছা just a minute
discussed, just prior to that paragraph.
এইটাতে আমি দেখিয়ে দিচ্ছি। এইটা দেখিয়ে চল 56 প্যারাগ্রাফ 56 ওরা দেখিয়েছে।
না 56
41 জজ সাহেবের ওখানে 41 প্যারাগ্রাফ দেখিয়েছে, যেটা এখানে আমাদের এটাতে
না মিলছে না তো এখানে
এইটা আমাদেরটাই মিলছে।
ইন ভিউ অফ
হ্যাঁ এইটা ওরা দেখিয়েছে, কিন্তু আমরা কি তার আগে থেকে দেখিয়েছি?
হ্যাঁ না কোথায় যেন হোল্ড করলো দুটো ইকুইভ্যালেন্ট নয়
হোল্ড করো।
Para 41. Para 41 last.
মানে that paragraph noting is different মানে your loss is paragraph 41 এইটাই তুমি দিয়েছো তো
না
না না
তোমারটা
রিপোর্টে দিয়েছে।
হ্যাঁ
এটা আনরিপোর্টেড, এটা
আর জজ সাহেবের কাছে এটা আছে তো
হ্যাঁ, এটা আছে।
সেটার জন্যই তো আমি চাইছি জজ সাহেবকে কি করে অ্যাসিস্ট করবো হ্যাঁ now paragraph 41 in view of what has been held by this court herein above we find that the high court erred in holding that 18 months diploma conducted by NIOS through ODL mode is equivalent to the 2 years regular diploma. Initially court held this, which is not equivalent. You cannot do that. Then the question come up, your lordships will find page 208. Your lordships kindly come. Here I will show your lordships certain things. Page 208, it starts Vishwanath versus Uttarakhand. That judgment. This is order dated or judgment dated 5th March 2025. This was, if I am not wrong, under review.
Yes.
Now I will be Malad placing some of the paragraphs of it. Why I am saying all this Malad factually I had taken to your losses. To paragraph page 209, paragraph 3. In 2007, 17,
Paragraph?
3 at page 209. Kindly see the Malad dates are almost coinciding with their appointment letters, all that. In 2007, an amendment had been carried out to the Right of Children Education Act 2009, which clause 2 was inserted in section 23 of the Act. The Right to Free and Education Act 2017 was made retrospectively applicable from 31st March 2005. Pause here for a moment. I had taken your losses to the sum of the letters of 2015. Why? Because of this. They obtained it subsequently. It's a private school. No preparation of documents required. On the letterhead, issue the appointment letter with a retrospective date. To cover up this gap and show that I am in-service teacher, I will show that, your losses. It was provided that every teacher who had been appointed or was in service on 31st March 2005,
15.
I'm sorry, 15, but did not possess the minimum qualification of 2 years as laid down on subsection of section 23 would acquire such minimum qualifications within a period of 4 years from the date of commencement of the Act of 2017. Therefore, what happens to your lordships? If you are in service teacher on 31st March 2015, you have to complete it within a period of 4 years. But that amendment came into effect of 2017. So what Malad actually happened if really a bona fide teacher is there? Because of retrospective effect, he lost 2 years. Clear to your lordships? Out of 4, he gets only 2 years more. Because of these, MHRD by notification of 2019 extended 2 years more for them. But what happens here, I will take your losses to judgment. Kindly visualize their appointment letters. All of them secured. Somebody more intellectual, they got it 2014. Somebody just give me before that to show that I am on service on 31st March. Nobody is there to check up these records. Because this was an ODL method. 18 months course, it's not a regular course. Got the one-time benefit, showing you in service teacher. But what else could be a fraudulent act on the part of these petitioners? Just to take the swallow the benefit of someone else's. You could have completed in the regular course. To avoid this, you have done this. Now see your lordships. 4. In view of the provisions of the second proviso to subsection 2 of section 3 of the Act, Ministry of Human Resource Development had issued a letter on 3rd August 2017 to all the secretaries of the state and union territories, directing that all the teachers in government school must possess minimum qualifications as mandated under the RT Act, and the last chance being given to all such teachers to acquire minimum qualifications till 31st March 2019. I said it because of this, MHRD extended 2 years more, because Act was given a retrospective effect.
Yes.
So they lost bona fide teachers, if anyone, they lost. That's why then. Next, then kindly see paragraph 5. Since the time gap between 31st March 2015 as provided in the 2017 Amendment Act and 31st March 2019 as specified in the direction issued by the MHRD was 18 months. The NCT issued a recognition order dated 22nd September for conducting DLED program through web mode by NIOS through SWAM portal of MHRD for in-service untrained teachers at elementary level working in the government unaided and unaided private schools. So what I am allowed, this is only for training qualifications. Very paragraph 4, your losses, only those who are possessing the other qualifications. Your losses getting it in the paragraph 4, last 2 lines in the page 209, directing, last 3 lines, directing that all the teachers in government schools must possess minimum qualifications add under the RT Act, and there's a last chance. Government schools, my lord, here later clarified that unaided private school also. But no clarification is needed because section 2N, you were covered by that. How could you ignore the notification of the NCT? Because you are governed by NCT also. Now, here, your lordships, what the court said, your lordships, kindly have a look at this. Kindly have running page 214. This is from Uttarakhand. Whatever, my lord, I will, my lord, the judgment appears, I have to accept it. Now, kindly have a look. My lord, paragraph 15. The grievance of the applicants herein is that though they are eligible as per the original judgment of this court dated 28 November 23 and the clarification dated 10 December 2024, in as much as the advertisement in the state of Uttarakhand dated 29th May 24, that is after the judgment was delivered on 28th November 2023, the state of Uttarakhand is not considering their claim. Here, my lord, there was an interlocutory order. Your lordships will get it, that in paragraph 20 of this judgment in next page. Why I am placing it? That might be they satisfied, they are qualified otherwise in service, all that. But that was not the scrutiny before the Honorable Court.
Yes.
We are before the first court of the Honorable High Court. So we are showing before losses they are not eligible to undergo the 18 months course. Now, your losses kindly come to paragraph 20. No doubt that this court has upheld 2012 rules framed by the state government by the judgment dated 28 November 2023. However, at the same time, this court had clarified that such of the teachers who were already in employment as on 10th August 2017 would be entitled to benefit of one-time scheme provided by the government of India. This court had held that such of the teachers who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or promotional avenues. Paragraph 21 is relevant, my lord, because, sorry, my lord, indisputably, the other institution would also include the schools run by the state government. Now, what they are now trying? In a backdoor process, you have secured 18 months course degree or diploma. Now you are asking this benefit of this. Allow me to appear like 2 years courses. This is a fraud, my lord. Why the genuine candidate will be defrauded by the authorities? He has, my lord, taken a regular course, not by any ODL mode. This is a one-time benefit. given to a really bona fide in-service teachers. Then, my lord, what happened? In another judgment which relates to our primary board, my lord, that's your lordships, Kaushik Chand, page 220.
কৌশিক দাস
কৌশিক দা হলো, কৌশিক দাস না, কৌশিক চৌধুরী বলেছি,
কৌশিক চন্দ্র বলেছেন।
sorry, no, Kaushik Das. No, my lord, here I tell you, lordships, one fact. When all these happening before the Supreme Court,
Yeah.
2022 recruitment started. Your lordship, initial judgment as I placed below 23. So we didn't allow any NYS.
না প্রথমে অ্যালাউ করেছি।
Oh, sorry. Yeah. We initially allowed. Some of them moved the Honorable High Court. Look, this is the judgment. Initially allowed 2022 NIOS.
তারপরে
Because in
তারপর
service,
আমরা বাদ দিই।
the court directed the Jaivis Singh judgment, you cannot, because this is not equivalent. We did not allow them. They moved the Supreme Court.
হাইকোর্ট
Initially lost before the High Court, before the division bench also, then Supreme Court. What the Supreme Court said, your lordships, kindly see. Paragraph 31 to 40, but precisely paragraph 40, Roman 5 and Roman 6. Your lordships, kindly take note of this.
4.6
Paragraphs 31 to 40, precisely paragraph 40, Roman 5 and Roman 6.
223 তে ট্যাক্সটা
Hmm?
23 তে
That's
4.6
And your lordships will get, my lord, in paragraph 223,
পেজ 223
page 223, paragraph 4.6, your lordships will get the facts. But I narrated before your lordships need not travel to your lordships to that extent. My lord, I take your lordship paragraph 32. It's, my lord, original judgment gets modified. Now, my officers, my lord, ask me, you tell me as a lawyer whether the original judgment of Jaivis Singh is still valid after these orders. Because Jaivis Singh, your lordship, said this is not equivalent. Then subsequently says it should be treated at par, those who are in service and course, my lord, 18, one-time benefit. To that extent, my lord, the original judgment gets modified. Obviously. Now, your lordships, kindly see paragraph 32. It can therefore be seen that even though the learned single judge of the High Court placed reliance on paragraph 56 of the judgment of this court in the case of Jaivis Singh, it came to the wrong conclusion inasmuch it put a blanket ban on all teachers holding 18 months of DLED through NIOS. My lord, what is a blanket ban? That means, my lord, what we understood. Our single judge, Public Justice Mantha, dismissed, allowed the writ petition and directed the council, don't allow them because Supreme Court says not equivalent. Then review came up, my lord, in judgment. No, Vishwanath. And then, my lord, this Kaushik. That means the Supreme Court says, rather, my lord, the views is that I have to cross-check up during the pendency. Those allowed, my lord, applied as NOIS, I have to see them whether really they are in service or not. Kindly see, put a blanket ban on all teachers holding 18 months. There might be bona fide teachers, there might not be, which I am saying that they are not bona fide. So it is an over exercise on the part of a recruiting body to qualify, scrutinize, examine them whether they were properly get it done or not. Otherwise, my lord, the bona fide candidates will be deprived. Now your lordships will find 31 to 40, I said, your lordships. Kindly come to page 247. Both the judgment and order of the learned single judge and division bench are quashed and set aside by Supreme Court. Then your lordships, page 247. Kindly see, my lord, Roman 5 and Roman 6. We clarify that such of the teachers who were in employment as on 10th August 2017 and who completed the 18 months DLED program through NIOS before 1st April 2019 shall be considered as a valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Then we direct the respondent authorities to consider the candidature of such applicants who were in service on 10th August 2017 and that who on verification are found to satisfy the eligibility criteria shall be appointed within a period of 3 months from today. Now, if we read together 32, paragraph 40, Roman 5 and 6, in the pending recruitment process of 2022, we have to scrutinize them. Really, they are bona fide teachers, not. And following that,
আরেকটা copy কোথায়? একটা কেন?
my lord, because of this, my lord, we issued a notification of 30th May 2005.
এটা তো important document, স্যার।
কতজন পেয়েছে দেখাতে গেলে
কোনটা কোনটা?
এটা এই proof দেখাতে পেরেছি গো?
না, এখন অব্দি কেউ দেখাতে পারে না।
No, my lord, kindly have a look of this notification. ওকেও তো একটা কপি দিয়ে দেওয়া উচিত না? আচ্ছা, ক্যানে আছে তোদের? My lord, then you just take the can. I don't know. I told my junior to bring 2-3 copies always.
65.
Your losses will get it 65 also.
হ্যাঁ, আচ্ছা।
My lord, Kaushik Das's judgment, my lord, kindly take note of 4th April 2025, and this is 30th May. We have quoted that. In compliance with the judgment of the Honorable Supreme Court passed on such and such in respect of such and such. Appeal number. In compliance with the judgment of the Honorable 4th April 2005 in civil appeal number such and such, has arranged a hearing for the verification of eligibility of the appellants on and from 1995. The appellants of the above mentioned petitions are hereby requested to attend the office of the West Bengal Board as per the enclosed schedule of time on 9th June to 18th June with the photocopies of all the documents. What we asked for, your lordships, kindly have a look at this. List of testimonial documents, mark sheet, certificate of Madhyamik Parikha and Higher Secondary. We have to satisfy your lordships that any valid document put of date of birth, TET pass certificate on or before 10th August 2017.
Because state mandate.
Because TET was mandatory, even if you engage yourself in unrecognized private. So that's why we asked for. Now, papers related to proof of in-service. Kindly see the second column. 4th, papers related to proof of in-service as on 10th August 2007, namely appointment letter, / accepted joining report of the appellants. Certificate issued by the school authority specifying the service of the appellant in the school on such and such. NOC cum registration certificate in favor of the school as on. And then salary statement. And nobody will be able to show your losses this because they are never appointed. Let them produce their bank account.
Yes.
Now, my lord, fortunately, in this up to my lord, pursuance of this notification of following 22 in respect of 22 selection process, none of the candidates attended.
এবং 90%
None of the candidates produced the documents.
অস্তিত্বই পাই 90% স্কুলে।
And according to our oral instructions, 90% of the schools didn't exist even. Now, what happened, your lordships? Instead of complying with this, the straightway moved the Honorable Supreme Court, if I am not wrong. Judgment wrong. That Kaushik Das. And now they have, my lord, on Kobeta withdrawal.
একটাও একটা কপি।
21st July 2005, they have withdrawn the petition from the Supreme Court. They questioned this 30th May 2005. And they withdraw it.
আগস্ট 23 আগস্ট 2010 সাল। জুলাই 2011।
Yes.
Now, your lordship, therefore, this notification in respect of 2022 selection process stands. Withdrawal means you are not questioning this even before the Supreme Court. So this stands. My lord, this was in view of the Kaushik Das's judgment in the pending matter. Now we are in a process of 2015 September 2025. So you have to satisfy first. What their prior year losses? Can you have a look at it? They are asking to modify the recruitment process, the notification. Page কত বলো in notification?
25th.
Page 97, prior year losses. Recruitment notification.
Recruitment 2025.
Well, kindly see prayer B, only this prayer. To modify and amend the impugned recruitment notification issued by the board by the memo dated 25th September 2005, to the extent that it includes and recognizes the petitioner's candidates, that should be our candidates, who had completed 18 months DLED course conducted by NOS, were in employment as on as eligible candidates. Now, my lord, I said, my lord, what my recruitment process, NCTE guidelines. So I have to read it now, Supreme Court NIOS order. JB Singh or your lordships, the other two, the modified, Vishwanath and your lordship Kaushik. Now you have to satisfy the honorable court that you got this like. Or let them produce all the documents before your lordships by way of supplementary affidavit. Scrutinize, we will scrutinize that. But we cannot allow them to participate like this. Anybody and everybody, because I tell your lordships, I'm a statutory authority. If someone complies with the conditions, all are equal to me. All. I cannot pick and choose. But I have to be satisfied before issuing the process that you are really qualified and genuine candidate. Why a process should be sent to a mess? It will be just like a mess, your lordships. Everybody is coming with a certificate. They do not satisfy the conditions. They were not appointed without any TET.
Yes.
So, they are therefore, your lordships, not being a bona fide in-service teachers, they cannot seek the benefit of Vishwanath and Kaushik Das's judgment. Vishwanath versus Uttarakhand on dated 5th March 2005 and Kaushik Das's judgment dated May 5th to 2025. These are my humble submissions.
23rd August 2010
কোনটা সেটা?
minimum eligibility criteria.
That's the loss. I did not. 23rd August 2010, your losses knows the minimum qualities.
Minimum
It is in this.
State must be, yes, sir, spiral binding. State must be there. Admittedly, 2020. These are my humble. But I just taking leave and come back.
Now, we'll have to start. I'm sorry.
Yes.
Now, we'll have to start with
How many applicants are there?
Lord,
Oh,
there are 4 applicants.
they will be respondent numbers.
Lord,
8, 9, 10.
8, 9, 10, and 11.
Yes.
Now, Lord, prescription of an eligibility criteria, Lord, it has a significant public law element in deciding the competing claims of eligible candidates.
Yes. Yes.
And my lord, selection of an ineligible candidate, it permits him to gain access to scarce public resources undeservingly. Lord, the other day, my lord, I cited an example of there being only one piece of loaf available to eligible candidates. If an ineligible candidate he is permitted to enter into the zone of consideration, he is going to take a pie out of that loaf undeservingly.
Yes.
But this lot has two consequences. But one, that the right of an eligible candidate is violated. But secondly, illegality is perpetrated by bestowing benefit upon an impostor who masquerades as an eligible candidate.
Yes.
But I draw inspiration from the submissions of Mr. Sanyal that the petitioners before my lord misrepresented themselves to be in-service candidates in gaining admission to the 18 months DLED course. The question is, Lord, whether the fruits of fraud can be permitted to be saved or any equity can be claimed, Lord, qua this fraud. Lord, I gain inspiration, Lord, from the well-known principle that fraud and equity do not dwell together. Lord, kindly sees, Lord, takes up my application, Lord, page 55, this has been shown to my lord. Lord, this is, Lord, 3rd August 2017.
Yes.
And this is, Lord, as a sequel, Lord, to the adjudication. And this is, Lord, issued by the NCTE. Lord, kindly sees the next page, Lord, page 56. The timelines along with key, my lord has very kindly got it, along with key milestones to ensure the training of all in-service untrained teachers is completed by 31st March 2019 are detailed in the table below. Lord, kindly sees 10th August 2017, appointment of nodal officer by every state and union territory. Then again, 10th August 2017, development of a dedicated portal by NIOS. And my lord kindly sees that this date, 10th August 2017, my lord, is the date which has been treated to be the cutoff date. My lord, to presume that all the competing claims in terms of the order passed in Jaivir Singh, my lord, they get a recognition in, my lord, the notification issued by the board on the 30th of May 2025, which my lord would very kindly get at page 55. 65. Lord, kindly sees, Lord, this is 30th of May 2025. And Lord, kindly sees the list of testimonials. Lord, kindly sees the third requirement, TET pass certificate on or before 10th August 2017. Now, this 10th August 2017, Milord, is no magical date. This is in conformity to the guidelines issued by the academic authority under the Milord RTE Act.
Yes.
Now, Milord, kindly, Milord, takes up, Milord, this short list of dates, Milord, this will Milord, assist your lordships, Milord, in gaining the placement of the relevant documents, Milord, in the records before my lord. Milord, My lord knows, my lord, 23rd August 2010 and 29th August 2011, my lord, the modification of the prescribed qualification laid down by NCTE. My lord, kindly, my lord, turns over the page. My lord, kindly comes to, my lord, this date. This is very important. 8th of November 2010. My lord, my lord, the Ministry of Human Resource Development, Department of School Education, Government of India permitted the state governments to seek relaxation of minimum qualification for appointment of primary teachers. Lord, kindly permit me to read the next few lines which are in bold. However, by the said notification, it was specifically intimated that condition of passing TET will not be relaxed. Lord, my lord would very kindly find this notification at page 8 of the compilation which I've handed up to my lord, the list of dates.
Yeah.
Now, my lord kindly sees this is 8th November 2010. Lord, the National Council of Teachers Education has, in exercise of powers under so and so, laid down the minimum qualification for persons to be eligible for appointment as teachers in school with a notification number 23rd August so and so and 25th August 2010. The notification has already been circulated to the state government and authorities. The notification can also be downloaded. Accordingly, all appointments of teachers in class 1 to 8 in respect of all schools referred to in so and so have to be made in accordance with the said notification. And then see, subsection 2 of so and so act provides that where a state does not have adequate teacher education institution offering courses or training in teacher education, or teachers possessing minimum qualification as laid down in subsection 1 of 23 are not available in sufficient numbers, the central government by notification may relax the minimum qualification. So it is only, my lord, the minimum academic qualification which, my lord, the central government, my lord, has a power, my lord, to relax. Required to appoint as a teacher for such period not exceeding 5 years as may be specified. And then, my lord, kindly turn over the page. My lord, kindly see, my lord, serial number 4. The condition of passing TET will not be relaxed by the central government. Now, my lord, getting back, my lord, to the facts of the instant case. My lord, the case made out is 2011 থেকে? My lord, the case of the petitioners is that they have been appointed from 2011 to 2017. My lord, I presume that when they make this, my lord, averment, my lord, in that event, my lord, they all are TET pass candidates, and hence, my lord, they have been appointed between 2011 and 2017.
Yes.
Now, my lord, kindly see, my lord, I shall show to my lord, that all these petitioners who have been, my lord, appointed, my lord, they claim to be appointed during 2011 to 2017, have, my lord, passed the TET examination either in 2022 or in 2023. Lord, kindly take note of the pages, my lord. I need not trouble my lord with all the pages of the writ petition. The page numbers where the petitioners' TET certificates of 2022 would be available are pages 110, 122, 126, 130, 134, 138, 142.
Yes.
So, my lord, as in 2011 or, my lord, until 2017, my lord, these petitioners, my lord, did not have the TET qualified, my lord, certificate.
Yes.
And my lord, in the teeth of the notification, my lord, dated 8th November 2010, which I just showed to my lord, they could not, my lord, have been appointed. This appointment, my lord, either, my lord, is illegal or, my lord, it's fraudulent.
Yes.
Now, my lord, Javeer Singh, my lord, has been placed before my lord. My lord, Javeer Singh, my lord, only created a one-time window for in-service candidates. But the presumption of such in-service candidates is not only, my lord, those candidates who have lawfully gained employment, my lord, upon fulfillment of all requisite qualification.
As per 23rd August 2010.
I'm grateful. My lord, I'm sorry.
Yes.
Because, my lord, 8th November 2010, it says that all appointments, my lord, must be given only to TET pass candidates. So a candidate, my lord, who was not a TET pass candidate could not have been appointed. And, my lord, such, my lord, candidates were not given the one-time protection of, my lord, being permitted to join the 18 months DLIT course.
But then how could these persons get admission to DLED course?
My lord, my lord, these, my lord, applications, my lord, were on, my lord, on online mode. My lord, they said that they are in-service candidates. My lord, the documents, the testimonials, my lord, were not verified properly. So they were treated on their misrepresentation. Today we question, my lord, as to whether they can reap the fruits of such misrepresentation and deceit.
Yes.
And my lord, kindly, my lord, takes up, my lord, my lord, list of dates. My lord, kindly sees, lord, the next page, page 3, my lord, will find a date, 1st April 2015. The central government, by a further notification dated 1st April 2015, extended the said relaxation for state of West Bengal till 30th of March 2016 and further clarified that the person having senior secondary or equivalent with at least 50% marks are also eligible for TET for class 1 to 5. But the purpose of showing this document is relaxation, whatever is being given, my lord, to the academic qualification. TET, my lord, requirement has not been dispensed with at any stage by NCTE
Yes.
or, my lord, in Javeer Singh or in Kaushik Das. Lord, kindly, my lord, takes up Lord Javeer Singh for a moment. And before that, my lord, I must say, my lord, that 30th of May 2025, my lord, which is, my lord, at page 65, my lord, was challenged before the Honorable Supreme Court by filing, my lord, an IA application. My lord, that challenge, my lord, was withdrawn. But I understand Mr. Sanyal has shown that. Now, it was also, my lord, construed by the petitioners that this imposition of a cutoff date for a candidate to have qualified the TET examination is also violative of the order passed in Kaushik Das. So contempt application was also filed. Well, the contempt application was also dismissed. Lord, this, Lord, was the order passed, Lord, in the contempt application. আমার কাছে আছে। My lord, I'm sorry.
Yes.
My lord, my understanding is, my lord, that a person aggrieved, my lord, will have, my lord, a locus to challenge 30th of May 2025 before my lord's court. My lord, in the prayers, my lord, I do not find, my lord, that any express challenge has been thrown to the propriety of 30th of May 2025.
Yeah.
My lord, kindly sees that this 30th of May 2025 was issued by the board in its own understanding of the effect of Jaivir Singh and Kaushik Das. This will not executive order till it will not remains in the file of the authority who is conducting the process of selection. Till it remains on the file, Milord, it has to be, Milord, adhered to, and that is, Milord, the understanding, Milord, which would emanate to all eligible candidates, Milord, who participate. They would know that, Milord, this is a criteria. So dispensing with the requirement of whatever is there, Milord, in the memo dated 30th of May 2025, Milord, the board, Milord, cannot permit the petitioners, Milord, by dispensing with the requirement of TET pass candidate certificate on or before 10th of August 2017. This requirement, Milord, cannot be dispensed with. Milord, kindly sees, Milord, Jaivir Singh for a moment. Milord, my lord has been handed over SCC online copy. Milord.
No, this is a
No, I hand
copy
up.
of the
Milord.
not SCC only.
Oh.
Jaivir Singh।
হ্যাঁ, Jaivir Singh। এটা দিন, এটা ফ্ল্যাশ কপি, এটা দিন। কেন এই ফাঁকে লেগে গেলে পরে? The scope of Jaivir Singh, Milord, has been, Milord, placed before my lord. Milord, I would invite my lord directly to paragraph 32.
Yes.
কতটুকুই ভালো। এই 23-এর পরে 35 চলে আসছে না, 34 থেকে ইয়েগুলো আমার কাছে নেই তো। Lord, kindly sees, as discussed herein above, the second provision to subsection 2 of 23 RT was inserted by the 2017 amendment 32. However, with retrospective effect from 1st April 2015, as such, the teachers who were appointed or in position as on 31st March 2015 were required to acquire the required qualification within a period of 4 years from date, that is 1st April 2015. The communication dated 3rd August 2017, the 3rd August 2017 is not referred, addressed to the additional secretary, will clarify the position. Then, Milord, 3rd August 2017, Milord, is already placed. I am not, Milord, repeating. It is thus clear that all the teachers working in either government-aided, unaided private schools were required to acquire minimum qualification or they would face dismissal from service. It appears that it was decided by the central government to provide a window for all such teachers. Let I pause here for a moment. So, my lord, this one-time window was given only to those who did not subserve the qualification criteria, that they should not attain the requisite qualification. A perusal of the said communication would reveal that various directions were issued so that lakhs of teachers who were untrained get the requisite qualification prior to 1st April 2019. The communication addressed by the director to the Chief Education Officer and the District Education Officer Uttarakhand would further clarify this position. It appears that in furtherance of the direction issued by the so-and-so, recognition order on 22nd November 2017 was issued. It will be relevant to refer the preamble. But kindly sees the second paragraph, the first paragraph, the matter of recognition of the project proposal of NIOS program through so-and-so for training of in-service untrained teachers was considered over several years. And whereas NCTE has received directions under the so-and-so act, the letter proposal, the project proposal of recognition of DLAD program through ODL mode has been submitted by the National Institute of Open Schooling to NCTE headquarters. The proposal is for conducting online so-and-so as per the first appendix. As per the NCTE notification dated 23rd August 2010 and 29th July 2011, one of the minimum qualifications of appointment of teachers for class 1 to 5 and 6 to 8 is 2 years DLED. As per NCTE order dated 22nd September 2017, program of NIOS is only for those untrained in-service teachers in government aided, unaided appointed on or before 10th August 2017. So in service as on 10th August 2017 presumes that he has fulfilled all the other qualification in terms of 8th of November 2010, more particularly with regard to the TET qualification, which has not been dispensed with ever since 23rd August 2010 came into being, prescribing for the qualification essential for appointment of a primary teacher.
Yes.
But this was not the issue before the Honorable Supreme Court. Now kindly sees that paragraph 39. It is thus clear that the entire scheme was for the purpose of providing a window to the in-service teacher in as much as unless they would have acquired requisite qualification on so and so, they could not have continued to remain in service and would have faced dismissal from service. As such, we find that High Court has erred in holding 18-month diploma conducted by NIOS mode is equivalent to diploma provided in the notifications dated. So it is not that this 18 months Milord was at any point of time Milord made as Milord an open offer to anyone who wants to undergo this training program. It was only Milord to ameliorate the Milord adversities faced by the in-service Milord teachers. And when I say in-service, Milord, then Milord, I presume that the Honorable Supreme Court Milord had duly taken cognizance of the fact that these in-service teachers are the appointees who have been appointed in accordance with the Milord prescriptions of 8th November 2010. Milord, kindly, Milord, comes to paragraph 49. We therefore find that the High Court has erred in directing the state government to consider the candidates who did not qualify as per the 2012 service rules. Milord, I pause here for a moment. Milord, in terms of this, Milord, the concerned state government, Milord, had framed rules. Milord, like in our case, Milord, the High Court, the Honorable Supreme Court, Milord, upheld, Milord, this and said that High Court erred in permitting those candidates who did not fulfill the qualification laid down in the 2012 rules. And as per advertisement based on the service rules, particularly when the 2012 rules and their advertisements were not under challenge. Number 3rd August 2017 is followed in the 30th September 2025 notification, both my lord lay down a cutoff date of 10th of August 2017. I say, my lord, neither 3rd August is under challenge, nor 30th of May 25 is under challenge.
3rd August you have annexed.
My lord, 3rd August, my lord, is here.
Yes, yes. 3rd August is 55.
My lord. My lord, kindly, my lord, comes to paragraph 52. In view of what has been held, I'm sorry.
Yes.
In view of what has been held by this court herein above, we find that the High Court erred in holding 18 months diploma conducted by NIOS through ODL mode is equal to 2 years regular diploma, particularly so when there was no material on record to even remotely hold that such a qualification was recommended by the expert body. On the contrary, the communication dated 6 September 2019 by NCT, the directors of MHRD, the recognition dated clearly goes to show that 18 months diploma was provided as a one-time window to the in-service teachers. And then paragraph 53, it again recognizes the authority of NCTE to lay down the guidelines, and the sacrosancy of such guidelines will not have been recognized in paragraph 53. That leaves us with reliance placed by the learned counsel for NCTE on the judgment of this court in Ramsaran Maurya. There can be no doubt that NCTE as an expert body has a right to prescribe the minimum qualification. In the present case itself, the notification dated 23rd August 2010, 29th July 2011, NCTE has done so. As already discussed, recognition order dated only provides a window for in-service teachers to complete the course. As such, the judgment does not apply to the present case. So, NCTE's authority in prescribing 23rd August or 29th July 2011 and the subsequent notifications have not been interfered with. If that be the case, then 8th November 2010, prescribing for TET examination qualification as essential for anyone to be appointed as a primary teacher, that stays. And in 2011 to 2017, these petitioners, none of them had this qualification. By admission, I have indicated the page numbers. These petitioners have gained the TET qualification not any time before the TET 2022 examination was held. The question is, as to whether these fruits of deceit and misrepresentation caused by the petitioner in misrepresenting themselves to be in-service candidates in gaining admission to the 18 months course, this can inure any benefit in equity to them or not. I rely on the decision 2017. This is reported in 2017. Please. 2017, volume 8, Supreme Court cases, page 670. Paragraph 56. Caste certificate fraudulently obtained by causing misrepresentation. That was a subject matter. The Honorable Supreme Court held, I shall show, that benefits reaped by such misrepresentation cannot be saved. Appointments cancelled, any other benefit reaped, that cannot be saved in equity, not even under Article 142 of the Constitution.
Paragraph 56.
Paragraph 56. That would be at page 724.
Yes.
Service under the union and the states, or for that matter, under the instrumentalities of states, subserves a public purpose. These services are instruments of governance. Where the state embarks upon public employment, it is under the mandate of Article 14 and 16 to follow the principles of equal opportunity. Affirmative action in our constitution is part of the quest for substantive equality. Available resources and opportunities provided in the form of public employment are in contemporary times short of demand and needs. Hence, the procedure for selection and the prescription of eligibility criteria has a significant public element in enabling the state to make a choice among competing claims. The selection of ineligible person is a manifestation of a systematic failure and has a deleterious effect on good governance. Firstly, selection of a person who is not eligible allows someone who is ineligible to gain access to scarce public resources. Secondly, the right of eligible persons are violated since a person who is not eligible for the post is selected. Thirdly, an illegality is perpetrated by bestowing benefits upon an impostor undeservingly. But kindly, Lord, comes to paragraph 65. Lord, may I?
Yes.
Administrative circulars and government resolutions are subservient to the legislative mandate and cannot be contrary either to the constitutional norms or to the statutory principles. Today, my lord, when I indicate to my lord, 8th November 2010, and then, my lord, I indicate my lord, 3rd August 2017, and then I indicate to my lord, 30th of May 2025, my lord, I say that all these, my lord, are in, my lord, one consonance. My lord, TET, my lord, has been held to be, my lord, mandatory in nature, and then to those candidates who say that I am in service and I want to avail of the one-time window, Lord, on the date when NCT is issuing a circular, it is saying that today, if you say that you are in service, I am fixing a date of 1 month hence, you would be presumed to be in service on that day. That window is open for you. And there, my lord, is, Lord, the mandate of the requirement of the TET pass qualification. So this cutoff date, my lord, has a significance.
Yes.
Lord, kindly sees, Lord, paragraph 66. One of the considerations which is placed in store before the court, particularly when an admission to an educational institution is sought to be cancelled upon invalidation of a caste or tribe's claim, is that the student has substantially progressed in the course of studies, and cancellation of admission would result in prejudice not only to the student but to the system as well. When the student has completed the degree or diploma, a submission against its withdrawal is urged a fortiori. In our view, the state legislature has made a statutory decision among competing claims based on a public policy perspective, which the court must respect. The argument that there is a loss of productive societal resources when an educational qualification is withdrawn or student is compelled to leave the course of studies cannot possibly outweigh or nullify the legislative mandate contained in so and so. Lord, kindly skip over, Lord, the next line. Lord, kindly comes to the line starting with the words, when a candidate is found to have put forth a false claim.
Yes.
My lord has very kindly got it.
Yes.
Of belonging to a designated class, tribe, or class whom a benefit is reserved, it would be a negation of rule of law to exercise the jurisdiction under Article 142 to protect that individual. Societal good lies in ensuring probity. That is the only manner in which sanctity of the system can be preserved. The legal system cannot be seen as an avenue to support those who make untrue claims to belong to a class, caste, tribe, or societal educationally backward classes. These benefits are provided only to designated so-and-so. Lord, I pause here for a moment. I draw an analogy. Lord, fruits of misrepresentation and deceit. Lord, in the case before, Lord, cited, this is in respect of, Lord, caste certificate, Lord, being falsely obtained, benefit being reaped. The Honorable Supreme Court said, even in invocation of Article 142, we would not save this. Today, Lord, there are petitioners before my Lord who say that we are in-service candidates. This, my lord, in-service status is a misrepresentation, is a result, my lord, of fraud and deceit. That is where, my lord, I draw an analogy and say that this status or the benefits, my lord, caused by such misrepresentation, my lord, cannot be, my lord, saved. My lord, only, my lord, one more paragraph, my lord, which is paragraph 73. Sorry. During the pendency of litigation, the respondent is retired from service and has even paid his terminal dues. Hence, at this stage, all that can be observed is no claim by a member of so-and-so caste can be observed, is that no claim by a member of so-and-so caste shall be made or entertained on behalf of the respondent, any member of his family, on the strength of caste certificate which has been invalidated by the scrutiny committee. So, my lord, the fruits of fraud have been permitted not to be reaped. And this, my lord, is a decision in rem for the entire community. If my lord today holds that those candidates between 11 to 17 who did not possess the TET pass certificate and yet represented themselves to be in-service candidates in gaining fraudulent, my lord, admission to the 18 months course, my lord, I say, my lord, in rem, my lord, they should be, my lord, penalized in a like manner, would not be, my lord, permitted to reap the benefits of such fraud and misrepresentation. তোমার প্রেয়ার ভাই ওদের পিটিশনে তোমার সাবস্ট্যান্টিভ প্রেয়ার হতে পারে না। My lord, just one more decision, my lord, I cite. My lord, this is, my lord, reported in 2016, volume 4, Supreme Court cases, page 791. For fraudulently securing benefits, my lord, under the Disabilities Act, my lord, Ramchandra Singh, my lord, 2003 Supreme Court, my lord, was relied upon, my lord, in paragraph 8. My lord, and fraud and its implication, my lord, has been spelt out relying on Ramchandra Singh. Fraud, as is well known, vitiates every solemn act. Fraud and justice never dwell together. Then, my lord, kindly sees, my lord, 17, subparagraph 17 of paragraph 8. It is also well settled that misrepresentation itself amounts to fraud. And then 18, a fraudulent misrepresentation is called deceit and consists in leading a man into damage by willfully or recklessly causing him to believe and act on falsehood. This is what the petitioners did when they declared themselves falsely to be in-service candidates.
Okay.
And then 23, an act of fraud on court is always viewed seriously. A collusion or conspiracy with a view to deprive the rights of others in relation to a... But this is not relevant, I'm sorry. But I beseech your lordships, but very humbly, that the petitioners before my lord, they were not eligible to, my lord, secure admission in the 18 months course, which has been held not to be equivalent to the 2 years DLAD. And they, my lord, cannot derive any benefit in respect thereof. The writ petition should be dismissed.
You কি হলো? Mr. Dasgupta, those two matters, 256 and 257, I am passing a single order, making it with, because at that point of time, I was of the notion that one of the matters with 22 and 23 and rest was with but I find that they are similarly circumstanced, so passing a single order. Yes, with, sure, yeah. Oh. Yes, Mr.
I
Chatterjee,
need some time. Can I come back tomorrow?
when, not tomorrow, after the vacation I'll take it up.
There, any day
After the vacation we'll do, in the first week itself I'll take it up.
kindly fix a date. And
Yes. Affidavit of service, Mr. Chaturvedi, can 1 of 2025. This is an application for affidavit of service filed on behalf of the petition is taken on record. This is an application for
My lord, I have a letter, my lord, I shall affirm in course of the day and will not file it.
Mr. Chaturvedi, learned senior advocate appearing for the petitioner, undertakes to file the affidavit of service. This is an application for addition of party. The petitioners contain that they are. Which paragraph? You have filled your form or you are aspiring
Yes,
to
my lord.
participate in the ongoing process? What is-
Yes,
we have filled our form. Hello, paragraph 4.
your paragraph,
Paragraph 4, supported by the annexures in P1 collectively.
The petitioners not full,
your
not
paragraph 35 of my application, I have stated
25.
35, 35. And the documents are at page 76 onwards.
They are candidates who have applied for participating in the ongoing recruitment process with a notification dated 25th September 2025, number 35 in Yanavel, read with notification number such and such dated 19th November 2025. They seek for impleading them as a added respondent. Mr. Chaturvedi, Piyush Chaturvedi, learned senior advocate appearing for the applicant, submits that the rights of the petitioners are very much will be affected by the prayers made by the petitioners, and as such they are necessary party to be impleaded in the present proceedings. Mr. Sobhusaji Chatterjee, on the contrary, Mr. Sobhusaji Chatterjee, learned advocate for the opposite parties, respondents, opposite parties, submit that the petitioners are no way, the applicants are no way affected by the prayer made by the petitioners, and therefore their prayers should not be allowed. Para, it is not in dispute that the petitioners are applicants in the ongoing process of recruitment initiated by the West Bengal Board of Primary Education pertaining to notification dated 25th September 2025. Thus, this court finds that the applicants are necessary parties. Accordingly, the applicants are added as
8 to 11.
respondents numbers 8 to 11 in the present proceeding. 8 to 11
My
in
lord,
the present proceedings. Can 1 of 2025 is accordingly disposed of. The name of the applicants be added in the array of the writ petition, array of the respondents in the cause title of the writ petition. এবার writ petition করুন আর Mr.
No. Amended cost title maybe.
Amended cost title, I'll provide them.
Learned advocate for the advocate on record for the petition is directed to serve a copy of the amended cause title to the learned advocate for the respondents. WP heard Mr. Sobhusaji Chatterjee, learned advocate for the petitioner, who concludes his argument. Mr. Subir Sanna, learned advocate for the board, also concludes his argument. Next argument is also concluded on behalf of the added respondent number 8 to 11. Mr. Chatterjee, learned advocate for the petitioner, seeks accommodation to place his replies. Is this matter date বলুন জানুয়ারির প্রথমের দিকে বলুন ninth 9 January.
Lord, arguments are concluded. Arguments are concluded by the respective parties. Will it be my lord's pleasure to keep it as a matter heard in part? Because my lord has heard everyone. I don't think Mr. Chatterjee would object.
Nothing will change.
Lord, item number 600, Lord, item number 606 will be taken up tomorrow at the top.
Don't know.
There is urgency, my lord. 1 marks is only required, my lord, pursuant to the expert committee report.
After the
On last
vacation,
occasion, Mr. Sannal took time, my lord. Your lordship fixed it today.
what to do?
Item
Nothing will happen in
Milord.
the.
It's a very
Your
urgent
What
matter,
changes,
Milord.
nothing will
If
going
Milord kindly
Milord,
fix it
will-
tomorrow,
my
Milord.
lord, last date
Milord,
is
item number 608, Milord.
my lord, item number 606 on last occasion, my lord, the
See,
board
we'll
took.
Milord,
Kindly take it up tomorrow, my lord. It is
Milord,
extremely urgent.
608, Milord has fixed today, Milord. If Milord kindly
You are
keeps
saying
it tomorrow,
today.
Milord.
Not tomorrow. Why
Then,
not?
my lord, on Wednesday, then, my
Milord,
lord, on
kindly,
Wednesday,
Milord.
Wednesday,
Milord,
your
it's very
lordship will be
urgent,
taking.
Milord.
Your
It's
lordship will
very
be taking
urgent,
up
Milord.
The first half there is mentioning, in the second half after 4:30 there is mention.
There is extreme.
Extreme,
Urgency after the vacation I'll fix date to
Milord,
hear out the matter.
Milord, extreme urgency, Milord. The
Taken up
matter is
today.
pending for over 2 years, Milord.
MSC appeal to talk.
My lord, kindly,
Milord, kindly, Milord.
kindly take it up day after.
Milord, Milord, tomorrow,
Last
Milord,
occasion,
tomorrow,
board
Milord.
took time, my lord.
Milord,
My lord,
kindly.
last
Heard
occasion,
you, I have heard you.
my lord,
Nothing will
last,
happen, going to happen in 7 and 10 days.
my lord,
Huh?
my lord, they will start the appointment process, my lord.
Start, Milord.
Milord,
Milord,
I
will
tell
be
your lordship,
prejudiced.
my lord, my lord, I tell your lordship, I mention the matter before your lordship, considering the urgency, your lordship fixed the matter last Monday. Your lordship took up the matter.
What to
Mr.
do,
Shan
sir? What
paid
to
for
do?
an adjournment.
We can at least try, no?
My lord, in the meantime, they will start appointment, my lord. This is the,
Milord, the petitioners will be prejudiced, Milord.
my lord, we have already applied, my lord. My matter will not take,
Yes.
Milord, one.
my lord, my matter will not take much time.
The matter needs
I
to
can take it.
Milord, this is for stay and continuation delay of 10 days. I have already deposited the 25,000.
Where is the service?
But it is the first day.
Where is the service of the copy?
No, I have not sub. The first day, we have to
Serve
get
the
a
copy of the section 5 application.
section 5.
Section 5 we have sent.
No. The initial will not 10 days delay, and also we have deposited 25,000 statutory deposit we have made. So, as usual, order will not stay, and we will deposit the balance amount within certain period, and we will serve the copy on the.
Which is section 5 application?
And 2.
Can 2 of 2025. This is an application for condonation of delay in preferring the appeal. One advocate for the applicant, sorry, appellant. Applicant is directed to serve copy of the application for condonation of delay upon the respondents and file affidavit of service on the returnable date. Can 1 of 2025. This is an application for stay of and 1 is stay of operation of impugned judgment and award dated 5th March 2025 passed by MSC Tribunal Fast Track Court, Baharampur, Murshidabad in MACC case number 74 of 2008. Mr. Toibalundi Bhomik, learned advocate for the appellant insurance company, submits that the appellant has already deposited the statutory amount of rupees 25,000 and is willing to deposit the entire awarded sum